Hello everybody, this is Aishley Verma, an intern with LEXIS and Company, and in today's video I will be dealing about a case which is related to right to succession. The case name is Vinita Sharma versus Rakesh Sharma, and the judgment was given in 2020. Citation of the case is Civil Appeal number 32601 of 2018. The bench consists of Justice Arun Mishra, Justice S. Abdul Nazir and Justice M. R. Shah. Relevant section related to this case is Section 6 of the Hindu Succession Amendment Act 2005. Head notes of the case is the Hindu Succession Act 1956, Section 6 of the same, which deals with devolution of interest in co-partnership property. After the amendment of 2005, the daughters are also included as a co-partner along with the sons. So facts of the case includes the plaintiff's father who purchased a premises which is the subject of the suit. Further, the family resided there after sometimes after there was a construction made, and few portion of the same premises was given to the tenants on rent. Further, the plaintiff's father had three sons and a daughter. After the death of plaintiff's father, the family came to partition. Meanwhile, one of the sons also died. Since plaintiff's father and brother died, she claimed property's partition for her share of 1/4. She says her few belongings are yet lying there. Uh, she was denied her share by her mother and brothers. She filed a notice for her share as well. In the reply of the same notice, the defendant said that the property is a Hindu undivided family property and the will is in the favor of the defendant, which was written by her father. The plaintiff says that the property was never treated as Hindu undivided family property and there isn't any existence of will from her father's end. Further, the defendant denied again, and there was another contention, and they denied her share by saying that the plaintiff, as married daughter, cannot seek partition in any Hindu undivided family property. She valued the daughter, the plaintiff. She valued the premises about 40 lakh rupees, and only 19.50 rupees was paid to her in the form of court fees. The case is the case is of Hindu undivided family property and the co-partnership rights of the daughters. There was a conflict in the interpretation of Section 6 of Hindu Succession Amendment Act 2005. Section 6 was discriminatory in terms of gender, negation on constitutional right of equality, insofar as the daughter of a co-partner was concerned. Issues that are related in the case are: number 1, if the property is Hindu undivided family property or self-acquired property. Second issue is which all parties are entitled to their share in the property. Third issue is if the suit is maintainable under Hindu Succession Act 1956 or not. Fourth issue is she, the plaintiff, eligible for the partition? And the fifth issue that is involved in the case is for the equal share in the property. Does the father needs to be alive? So the points of derivation in the case are: number 1, the property is a self-acquired property for the father, but after his death it becomes a Hindu undivided family property. Further, as the property is declared to be a Hindu undivided family property, uh, the Hindu Succession Act 1956 is applicable on it. After the amendment of 2005, Section 6 of the same act conferred equal rights on daughters as well as on sons, that is, full co-partnership rights was given to the daughters. Section 6, Clause A, Clause 1, Subclause A of the Act conferred co-partnership rights on daughters by birth under Mitakshara law governing the family. So the judgment came in the favor of plaintiff. So the judgment of Supreme Court held that in this case referred to various Supreme Court referred to various principles of Hindu law, both codified and customary, such as co-partnership and joint Hindu family, obstructed heritage, unobstructed heritage, and everything. The court, after examining, said that it is a kind of property where the right of partition is absolute and it is given to a person by virtue of his or her birth. The court, by observing these situations, held as the right to partition is by birth of the daughter unobstructed heritage. It is immaterial if father as co-partner was living or dead on the date of the amendment was done. Therefore, the court overruled the judgment which was already given in Fulvati versus Prakash's case and said that the compulsory rights passed from the father to his living daughter and not from living co-partner to living daughter. So there was a clarification made. Further, the court also explained the application of retroactive law which is applicable here. The court stated that Section 6, Clause 1, Clause A of the Act incorporates the definition of Mitakshara Kopasnaries, unobstructed heritage, conferred by birth. Since the right is conferred by birth, it is an antecedent case. The provision applies on and from the date of enactment of the Amendment Act, thus making it retroactive. Hence, the amendment by way substitution of Section 6 of the Act of 2005 is retroactive in nature. So, concluding the topic, so the verdict of the case has cleared the uncertainty about the law and made it clear that the amendment of the Hindu Succession Act granting equal rights to inherit the ancestral property to the daughter would have a retrospective effect. Court also perceived that gender cannot be a ground for denying anyone with their inheritance rights, as it is a violation of Article 14 of Indian Constitution, that is equality before law. The verdict has successfully resolved all the ambiguity that was earlier passed in the case of Fulvati. So that is it for today. Thank you so much.